NACDL is the association of the nation's criminal defense bar.
Hello and welcome to the headquarters of the National Association of Criminal Defense Lawyers, NACDL. I am Norman Reamer, Executive Director of NACDL, and it's my great pleasure to launch this first in a series of sentencing skills presentations. Our goal with this project is to help frontline defense attorneys throughout the country employ cutting-edge litigation strategies to obtain relief from the draconian sentencing practices that are so widespread in this country. We launched this program knowing that America today has approximately 2.3 million prisoners, more than any other country on the planet. Today, we're going to provide a broad overview of litigation possibilities that may be enhanced by the Supreme Court's recent decisions in Graham v. Florida and Miller against Alabama. These cases established new Eighth Amendment limits on when and how states can impose life without parole prison terms on juvenile offenders. The cases have also given new life to the proportionality analysis, and specifically the idea that some prison sentences may be so lengthy as to violate the Eighth Amendment's prescription on cruel and unusual punishment. In this regard, with support from the Foundation for Criminal Justice and the Ford Foundation, NACDL has developed a new resource that provides instant online analysis of state-level jurisprudence regarding the Eighth Amendment and analogous state constitutional and statutory provisions. The resource is designed to aggregate state constitutional and statutory provisions as well as emerging case law to inform litigation strategies that challenge sentencing severity. It includes profiles of every state. These profiles and the accompanying charts are intended as a resource for practitioners in all phases of the criminal justice system, for sentencing and appellate courts, for policymakers and advocates concerned with the high economic and human costs of excessively long terms of imprisonment, as well as for defendants facing or serving extreme prison terms. More than half a century ago, in Trop v. Dulles, the Supreme Court stressed that the scope of the Eighth Amendment is, and I quote, not static, but must draw its meaning from the evolving standards of decency that mark the progress of a maturing society. State-level doctrinal and jurisprudential developments have thus always had heightened federal constitutional significance in this area of law. Moreover, state policymakers and state jurists have long understood that the Eighth Amendment sets only a minimum constitutional floor, limiting only the most extreme punishment policies and practices. State lawmakers and judges can and should feel not merely free, but institutionally obliged to consider developing their own distinct legal limits on unduly harsh sentencing terms based on distinct state-level requirements and needs. NACDL's new resource demonstrates that even though there is some notable convergence in state-level proportionality doctrines, there is also some important variations and innovations concerning how states limit extreme or excessive criminal punishments. This new resource may be accessed at www.nacdl.org/proportionality-resources. Now, to launch our discussion today, we present The Resurgence of the Eighth Amendment, Graham, Miller, and the Return of Proportionality Review. We feature two extremely distinguished guests. First, Douglas A. Berman is the Robert J. Watkins Procter & Gamble Professor of Law at The Ohio State University Merich College of Law. Doug has also overseen the development of NACDL's new proportionality resource. He has degrees from Princeton University and Harvard Law School, where he served as the editor and developments office chair of the Harvard Law Review. He clerked for Judges John O. Newman and Guido Calabresi of the Second Circuit Court of Appeals. After clerking, Doug Berman was a litigation associate at the law firm of Paul, Weiss, Rifkin, Wharton, and Garrison in New York, and then shifted to teaching and writing. His principal focus is in the area of criminal law and sentencing. Doug is a co-author of a casebook, Sentencing Law and Policy, Cases, Statutes, and Guidelines. He has served as the editor of the Federal Sentencing Reporter and is the creator and author of a widely read and cited weblog, Sentencing Law and Policy, which now receives approximately 100,000 hits per month. We're also pleased to have Stephen P. Hardwick. Stephen is an assistant public defender for the Ohio Public Defender's Office in Columbus, Ohio, where he specializes in appellate advocacy on behalf of clients convicted of capital offenses and other felonies. He has extensive experience handling both direct appeals and collateral review on both the state and federal level. Stephen has argued more than 20 cases in the Ohio Supreme Court and countless more in the intermediate appellate courts in Ohio and in the Sixth Circuit. Stephen Hardwick earned his BA with honors from Grinnell College and his JD from the University of Michigan. Go Blue. Stephen is a former instructor in English for the Peace Corps, having served for 2 years in Tunisia, and he is currently the chair of the amicus committee for the Ohio Association of Criminal Defense Lawyers, an NACDL affiliate, I'm proud to say. So let me kick this discussion off with a simple question for each of you. Doug, from an academic standpoint, and Stephen, from the practitioner's perch, what's the big deal about Graham and Miller?
Well, thank you, Norman, for that very gracious introduction and for setting up the both easiest and hardest question we'll discuss today, I think, what makes Graham and Miller such a big deal. I'll try to keep it on an academic perspective, but candidly it's with an eye towards practitioners that a lot of my excitement about Graham and Miller come to bear. In the most simplest way, what make Graham and Miller a big deal are that the Supreme Court has finally, and in my view far too late, but fortunately better late than never, brought its robust Eighth Amendment jurisprudence, which has prompted an incredible amount of regulation of capital sentencing. So we've seen the death penalty used somewhat controversially, but still always robustly as a mechanism for the Supreme Court and for lower state and federal courts to significantly shape and impact the way in which death penalty cases and death penalty sentencing in particular takes place. And whether or not we think that it's ideal what the court has done in the death penalty arena, what hasn't been ideal from my perspective for sure is never has any of the jurisprudence crossed over to the non-capital arena. In fact, disappointingly, and the predecessor case of Harmelin going all the way back to the early 90s sort of set this tone, the Supreme Court seemed to have been saying for purposes of non-capital sentences, long prison sentences, that basically anything could go constitutionally. It was up to legislatures, it was up to executive discretion, whether and how even the most extreme kinds of prison sentences, life without parole or variations thereon, could be imposed in any case, no matter how minor. In fact, there's some terrible dicta in one of the early Supreme Court Eighth Amendment cases on non-capital settings that, well, I guess there would be an Eighth Amendment problem if you got a life sentence for jaywalking, but we'll never have to deal with that, so don't worry about it. And particularly distressing prior to Graham and Miller was lower courts taking signals from that impression, not just concluding as a matter of federal constitutional jurisprudence that just about every Eighth Amendment claim to an extremely long prison sentence was a non-starter, but in state courts largely following in step, saying among other things that state proportionality doctrines, constitutionally at least speaking, and every state has some kind of cruel and unusual punishment clause or proportionality clause of some sort, but state courts were often quick to say, well, at the federal level there's really no Eighth Amendment claim to a long prison sentence, and we think that's sort of good enough for government work for our state constitutional jurisprudence as well, even though, interestingly, that's not often been the case for capital jurisprudence in the states, and even though I would hope if the Supreme Court at the federal level isn't going to have constitutional doctrines develop here, that the states would fill in those gaps. And they have in some other settings, but that didn't happen much when it came to extreme prison sentences. Graham comes along, and Graham then ends up representing the first major modern U.S. Supreme Court case that says a term of years prison, in that case a life without possibility of parole sentence for a juvenile offender convicted of non-homicide offenses, is categorically unconstitutional under the Eighth Amendment, categorically disproportionate. Miller is the wonderful and, in some sense, dynamic follow-up case that actually doesn't put any particular sentence off the table. It says that life without the possibility of parole for juvenile murderers is still a constitutional possibility, but says that Alabama and Arkansas, which had that imposed mandatorily, now violates the Eighth Amendment. And especially notable in both cases is the way in which the court referenced its capital jurisprudence to justify these non-capital rulings. There had been, and it's understandable both as a matter of doctrine and as a matter of practice, this incredible death is different jurisprudential foundation to all the court's Eighth Amendment work. And interestingly, in Graham, Justice Thomas expressed concern. Wow, we could do all sorts of Eighth Amendment jurisprudence in the capital cases, but we wouldn't have to worry about that extending to prison sentences because we always said death is different. Now with this Graham ruling, that's no longer the case. And he suggested that was a problem. I see that as an opportunity, not just an opportunity for finally developing long-needed proportionality litigation jurisprudence at the federal level under the Eighth Amendment, but also hopefully turning the corner for states, lower courts, litigators across the nation to see that just because it's a long prison sentence doesn't mean you don't have a constitutional claim. And later in this program, I hope we'll get some more detail into how Graham and Miller are very different kinds of cases and rulings, and how that very difference gives litigants different kinds of opportunities to leverage different parts of existing Supreme Court doctrine and maybe existing state doctrines in order to attack long prison sentences. So the fact that we finally overcome what I long saw as a harmful death is different divide that prevented constitutional jurisprudence from evolving in the way I think it need to in this arena in light of those statistics you mentioned, Norman, is what makes Graham and Miller such a big deal, and I think provides not only this incredible moment of opportunity, but makes me so grateful to NACDL in focusing resources and attention on this doctrine, not just for juvenile offenders, which we'll talk about, but for other potential offender populations in a range of other potential settings. So that's an ivory tower perspective on why it's such a big deal. Perhaps Stephen has a different perspective on why these cases are worthy of our extended attention.
Well, I think in the short run and from a practical point of view, the most important parts of point of Miller and Graham is that there are hundreds, if not thousands, of children in prison in the United States who, before these decisions, had no hope of ever walking out of prison alive. And these two decisions give them hope, some chance to walk out the door. And even if we end up losing their claims in the end, it is living in prison is very different if you know you will never walk out the door. If you think you have a chance you may have a chance at parole somewhere down the line, your incentives for bettering yourself and learning to get along are greatly improved, and just the depression that can come with no hope is something that's good to get rid of on its own. Secondly, for everyone, there is in both Graham and Miller, and it's the predecessor decision, Roper, a goldmine of psychological analysis. And the great thing about that is that it's not just good psychology. It is now good psychology with 5 votes on the United States Supreme Court, which means that regardless of the case, you can now go to that opinion, look at the studies they cited, and when you go to your local trial judge, say, no, this isn't just some psychologist. This is 5 votes of the U.S. Supreme Court. It's law. You have to pay attention to it. Another gift that they've given us is just a reminder of how to represent children in the system and to use the language of children when you represent children. Too many of us who are used to handling adult cases get used to calling our clients Mr. Smith or Mr. Jones. We need to learn to start calling them Bobby and Chazz and by their first name. And there is a very nice discussion between Justice Alito, who complains about this language of children in his dissent, and Justice Kagan, who says that this is just reality, this is what we called them. And one nice thing about that is, if your opposing counsel or the judge gives you any problems with using the language of children, you can point to Alito's dissent and say, yes, that's exactly what Justice Alito said, and he had 4 votes. And there are and I think it's important to read the dissents in those cases, because a lot of the arguments you'll hear from prosecutors and resistant judges will be arguments that were made in the dissents, and it is very helpful when you can call them on that and tell them, to point out to them that their argument was considered and it lost. And specifically, I have 2 clients and a couple who I am actually litigating, and there's at least one more hanging in the wings. We're trying to figure out what I can do. A couple more hanging in the wings. I need to figure out what I can do. And the NACDL has been helpful in both of them. The case of Chazz Bunch versus Bobby, it's now out of the Sixth Circuit. But
let me pause on that, because I want to talk at least a little bit about what might even be thought of as the low-hanging fruit of Graham and Miller, about just some of the points that you picked up on, Steve, about what it means about juvenile representation in the criminal justice system and the way in which that feeds into challenges to extremely long sentences for juveniles. And then I hopefully will, by making those general comments, introduce the 2 cases that you have and give you a chance to talk them through. But the point that Steve made that I think is also reflected in some of the academic commentary that's flowed from Graham and Miller, and is in some sense, understandably, I think, the focal point for the first round of litigation, and necessarily the place in which we're going to be seeing the most action in courts, in briefing, in the work being done in their wake, is a jurisprudence of juvenile children being special for sentencing purposes. And I share Steve's great insight that it's taken too long to get there, and too long not only because part of what has led to the Graham and Miller decisions had been, throughout the 80s and the 90s, a strong effort by prosecutors, by legislators, to turn children into adults for criminal justice purposes. And this is a topic that I know is going to be continue to generate debate legislatively. It may be one of the frontiers for litigation concerning kids, whether there are some limits about even whether and when juvenile defendants can be bound over to adult court and what the procedures for that are. I don't anticipate spending a lot of time focused on that in this program, but there's no doubt that Graham and Miller, and as Steve mentioned, the predecessor Roper, provides a lot of material for making even broader arguments about limits on how the juvenile justice system can become like the adult justice system. And in fact, the juvenile justice advocates who have done terrific work in this arena are quick to mention a recent juvenile custody case, which also has good language about kids being different for Miranda purposes and the like. And so one of the themes among the academic arena, and to some extent I think inevitably part of the public policy advocacy that follows from these Supreme Court decisions, is kids are different. They are so different as a matter of brain science. They are so different as a matter of potential that we need to treat them differently as a matter of constitutional jurisprudence. And not only do I not dispute any of that, I wholeheartedly embrace it. But one of the goals of this project, one of the goals of the work that I've been trying to do with students to put together state proportionality resources, is to not let Miller and Graham become only about that, because they have so much more to them. And I don't want to either stop Steve from telling us about how he's using them for his juvenile clients, but at this stage I wanted to emphasize, though I'm certain what we're working on and the things that we're thinking about both through this NACDL project and in our own individual work on these topics, necessarily start with using the juvenile justice components of what Graham and Miller say and talk about and talk through, that a big part of what I'm eager to have us discuss later in the hour and to have the folks listening to this program think about are ways in which the doctrines, the ideas, the frameworks being established for the Eighth Amendment in Graham and Miller can be leveraged and utilized to serve a range of offender populations, whether we think they're like juveniles or very dissimilar to juveniles, and to be thinking about extreme sentences for particularly lesser crimes, but even for extreme crimes. That's another dimension of what makes Miller such a potent and important follow-up to Graham. Graham had as one of its foundations not just that it was a juvenile offender, not just that we were talking about the extreme sentence of life without the possibility of parole, but also that it was a non-homicide offense that was in play in those first sets of cases. Miller involves first-degree murder cases, and because of that, it's another reminder that proportionality litigation is not just about lesser offenses and more extreme sentences. It can be about a variety of dimensions of extreme punishment practices for a variety of offenders in a variety of settings. And so that's one aspect I encourage everybody thinking about these cases to not just notice their importance and significance on the ground for juvenile offenders in a variety of settings, but also to start thinking as dynamically and, in my sense, aggressively as possible about the ways in which Graham and Miller service a broader set of constitutional and policy principles. And here I'll just echo Steve's point about reading all the dissents and all the concurrences in these cases, because that's another piece of the equation. Both in Graham, Chief Justice Roberts had an interesting concurrence that actually provides the foundation for a different way to approach this litigation that hasn't gotten much attention so far for understandable reasons. Likewise, in Miller, Justice Breyer has a concurrence that also talks through ideas that may extend to attacking felony murder convictions in some kinds of settings, and so there's a lot of there. So that's the other point I wanted at the outset to make sure that everybody's on board with, is not just the importance of these decisions as a new frontier for Eighth Amendment analysis, as obviously an area in which children languishing in prison get new hope and get new opportunities for their counsel to argue new points, as Steve will tell you about in some of his cases, but that can at least provide a glimmer of hope to just about everyone serving a sentence they think is unduly lengthy, unfair, procedurally improper in some way, shape, or form. Because one of the things, and again to use the incredible work of capital litigators as a model and an aspiration, one of the things that great capital litigators do, no matter what the odds they face, is provide hope for their clients, provide a justifiable belief that somebody is there fighting for them in an effort to, at the very least, require the state to work awfully hard before they carry out death sentences, but even more to know that notwithstanding their criminal activity, there are people in the system who are still fighting for their interests, whatever they may be. And in the same kind of way, that's among the reasons why I'm so excited about this project, because it provides a new opportunity for those representing a range of other defendants in a range of other different settings that can sometimes look jealously upon their capital defense brethren in prison, and know that there's an incredible amount of energy and activity across the board to try to get people off death row. The idea not just that we'll do that to try to get children with the possibility of parole, but to get anybody enduring an unfair and extreme sentence to believe there's at least a chance to use these new developments to serve their interests, I think is something that makes this project profoundly valuable, regardless of what the day-to-day outcome is in the courts.
And I think, going back to what you said about bindovers, I know one of my colleagues in our juvenile division has made it one of her missions in life to use Graham and Miller to end mandatory bindover for children. And she does have, and there is language in there that she can use to do that. And that, of course, brings up one problem we have in the public defender world, that over time, it's one very good thing that's happened is that juvenile law has become a specialty, and that juvenile lawyers go to conferences and learn the specialty and how to deal with children. Well, the problem then becomes with these cases is these cases generally end up in the adult division of a public defender's office, where you have people like me who haven't gone to those seminars. Well, I think, first of all, I think we now have to start going to those seminars, or at least spend time talking to your juvenile law colleagues to partner with them. And on the flip side, a lot of juvenile lawyers who deal with these cases at the bindover stage or in juvenile court don't understand the adult system, and that's not a charge against them. That's not a criticism of them. It's just the reality that you understand where you are. So these serious cases may require offices like mine to rethink how they do these cases, to pair the adult lawyer with a juvenile lawyer who knows what they're talking about, or get someone who's cross-trained people. But
That's a great segue into partnerships, because I know that one of the reasons I was so excited you could be a part of this program, Stephen, is because you're kind of on the cutting edge of efforts by NACDL to help out with some of the next wave of juvenile litigation in state courts and up to the Supreme Court on some of the extensions or need to apply Graham and Miller in some different settings. And so I'd love to give you a chance to talk about both of the cases that are keeping you occupied in the role that not only NACDL is trying to play to help out, but what broader views you have about the ways in which a project like the one we're launching here at NACDL can continue to be value added and a resource that folks on the ground can utilize effectively. Well,
in the two cases I'm involved with are actually in litigation now, and the NACDL is helping out with both of them. The first one is Bunch v. Bobby. Chazz Bunch is his name. He was first given 89 years. He was given an 89-year sentence for a rape and kidnapping that was all a signal event. That was a combination of 10 and 3-year sentences that the judge maxed and stacked him up to 89 years. Thanks to sentencing reform and a bill recently passed by the Ohio General Assembly, he is now eligible to ask a judge for early release after serving a mere 79 of those 89 years. And essentially that is life without parole. He cannot ask for release until age 95. And what's interesting is that there is a lot of resistance among lower court judges to apply Graham to anything but sentences with the label life without parole. And I think that's nonsense. They didn't outlaw a label, they outlawed a sentence, they outlawed a reality. And that's what we are arguing in a cert petition now in the Chazz Bunch case. So I lost this issue in the Sixth Circuit. I was Chazz's lawyer from an appeal from his resentencing. We raised this as a Roper claim in the State Court of Appeals. It wasn't raised by the trial lawyer, but fortunately our State Court of Appeals gave me a wonderful gift by giving me a merits decision, which we took up to the Ohio Supreme Court. They didn't take it. We lost in the district court, and just after the district court wrote an opinion saying there was no chance I could ever win this claim, they issued that opinion, then Graham came out, which made it a lot easier for me to get a certificate of appealability, but I still ended up losing the case in the Sixth Circuit. Almost within a day of me losing that, possibly the same day, a partner from one of the larger law firms, Jones Day, gave me a call and says, would you like some help with this? And the answer was yes, and so I'm now partnering with Jones Day and the clinic of the West Virginia Law School, and they helped me. We have a much better cert petition than I would have ever filed on my own. And that's one area where organizations like this can help, is that a lot of us who practice this on the ground don't have much experience with the U.S. Supreme Court. And I filed less than 10 cert petitions. I've never gotten one in. And it is wonderful to be working with someone who knows that court, who understands that court, who knows the quirks of the procedural issue, even things like how do you actually physically make sure something gets to the clerk's office on a certain day, which is different in the U.S. Supreme Court than it is someplace else.
And let me pause to talk about the Chazz Bunch case just a little bit, because it's one variation of the kind of first-generation Graham issues, and Steve did a beautiful job of highlighting that there's a tendency, and we're seeing this not just in Ohio, we're seeing this nationwide, to try to limit Graham to only life without parole labeled sentences. And valuably, one of the leading state-level cases that has resisted that is a California Supreme Court case that declared a 100-year term of year sentence to be a life sentence for all intents and purposes, and said that Graham applies to a 100-year term of sentence. What's obviously clear in the Bunch case, what is at play, I think, in lower courts somewhat resistant to allowing anything but a life sentence to implicate the Graham principles is, well, okay, you say 100, what about 75? What about 50? What about 25? And, of course, there are obvious lines to be drawn there. And to their credit, some lower courts have looked at life expectancy tables and so said anything that's a sentence that will have to be served that go beyond the defendant's life expectancy qualifies as life without the possibility of parole. But there are other courts that have said, no, that's not the right way to do it. Some courts have even gone so far as to say, well, we don't know what life expectancy is going to be in the future, and so we shouldn't use that that basis for doing it. So this basic issue of even what does life without parole mean relative to other extreme sentences is something that not only is worthy of lots of litigation, but there's every reason to believe will find different expressions in state courts across the country. And again, this is a story that taps into some of the broader themes and goals of this project. Even if the Supreme Court eventually takes up this issue, and I hope for Steve's clients they do it right away, not eventually, but whatever the particulars may be, and whatever the court may end up saying. Perhaps the court will end up saying, well, 75 is our magic line for juvenile offenders, and if it's over 75, it's functional LWOP. If it's under, who knows what line they may try to engineer when they take this issue up. That shouldn't prevent whatever line is drawn a state Supreme Court from saying, as a matter of state constitutional doctrine, we think it should be something less than that, or we think that the broad language of it's important to provide people with a meaningful opportunity for release, which is some of the key language of Graham, means meaningful while they're still able to walk and not be gurneyed out of prison. And my instinct, and here I'll show my own inclinations, something in the neighborhood of 50 years is probably the max that I think, even for a juvenile offender, that shouldn't be seen as a functional life sentence. And here again, just thinking as an academic, thinking about ways in which developing this litigation going forward, both in courts and in research, right? I don't know if we have actuarial tables for juveniles sentenced to extreme punishment schemes. My guess would be many of them don't live the normal life expectancy of an equivalent juvenile somewhere else.
And I think actually that's one thing. Actually, this is one area where I think we should try to not fight on that turf, which is life expectancy tables. And Professor Berman was right that the case talks about.
You can call me Doug. Please do. I'm calling you Steve.
That talks about the meaningful opportunity for release. And my argument has been that Graham does not ban life without parole. It requires a meaningful opportunity for release. That is the holding, and then it was applied to a sentence labeled life without parole. And if you tell it, I think one thing to look at this is from the perspective of a 16-year-old. If you talk to a 16-year-old and told him he will have an opportunity for a release when he is 70 years old, would he consider that meaningful? I don't think any of us would have considered that meaningful at age 16. And one thing we have to be careful about is we are often pitching these cases to judges who are 65, 70 years old. So we do have to be careful about how we deal with that. But I think that's why it's important to focus on from the perspective of the child, what is meaningful. And the cases do give us some guidelines, because they talk about brain development. The brain development basically completes in the mid-20s. And so there's actually an argument that their meaningful opportunity for release comes even shortly after that. One problem we then have is, well, what happens if our clients now become immediately eligible for release? They get their parole hearing, but they've lived such a hopeless existence that they have a horrible prison record. And that's what happens to a lot of these kids when they go into prison and have no hope. For some, it's not surprising they get bad prison records, and they will need time to develop a good prison record to show that they are entitled to release. And so there is a tension there where you want it to be early, but you don't want it to be too early. How individual do you make it? And I had one hypothetical that I have to say that the local federal public defender down in Cincinnati predicted, and they even asked me an oral argument, what would you do with a 16-year-old with a 4-year life expectancy? It had a disease that will die in 4 years. Could you give that person a 5-year sentence? And that we will have to deal with hypotheticals.
Yeah, and all of those are not only questions that are absolutely fascinating, they actually present, and again, to keep bringing the broader picture in here, one of the challenges to extending Graham in particular to non-juvenile populations, because in the same way as, okay, a dying juvenile, maybe a 5-year sentence serves as a life sentence, we often see, particularly for older offenders who have committed for the first time pretty serious crimes, statements by defense attorneys just in doing effective advocacy, Judge, don't give my guy 20 years because that's tantamount to a life sentence for my guy. And that may be true, but that's again a component of understanding not only the challenges of extending Graham, but being sensitive to developing arguments that may or may not only serve your client, but serve the jurisprudence writ large. And obviously that's a broader challenge that all defense attorneys necessarily face. Their obligation is to their client. Their obligation is to leverage whatever arguments serve their client's particular facts and particular interests. But one of the things that I hope to do as an academic, that I hope with the help of NACDL and others involved in this litigation, is to provide something of a hopefully helpful go-between. There may be certain kinds of arguments, whether it's about life expectancy, whether it's about what kind of term of years ought to count, that defense counsel actually arguing the case may be less comfortable or less able to bring. It may even be a part of the client's own wishes that they don't want to push forward with a certain kind of argument in certain kinds of settings, but that NACDL might be uniquely able, whether it's to bring facts on the ground to inform the discussion, whether it's to be able to articulate certain jurisprudential perspectives that may be hard for the individual defense counsel with that individual defendant to present. And that's, again, something where NACDL's commitment, my commitment, certainly is always going to be to work with the defense attorney representing that client and knowing that client's interests, knowing the unique local circumstances to help develop arguments that are helpful to that respect, but also that perhaps the help comes in enabling arguments to be made that may be uncomfortable or challenging from a local environment perspective. And here, Steve, I'll add, sometimes it may also be the flip side of the story about local expertise. You mentioned you got to realize, and I know this from Ohio as well, you're arguing to 65 and 70-year-olds when you're practicing in the Ohio courts, but we have a mandatory retirement age. In the federal courts, you may be often arguing to folks for whom they remember fondly those youthful days of their 70s. And so, again, those are things to be sensitized to, and that, again, I'm hopeful that this project will continue to try to work with individual defense counsel in a variety of settings to think through these issues so that it's not just a choice that's made strategically at that moment, but that considers the range of possibilities and in particular doesn't let resource constraints or uncertainty about local practices reduce or even eliminate the ability to put forward the best possible argument.
And practically, one thing that having amicus help has, this helped somewhat in it helped in the Sixth Circuit, and I think it's even more important when you're at the cert stage or any discretionary review stage. Is these are often the first time these judges will hear this claim. It is new and it is weird to them, and having an amicus there when no one else is paying attention to the case tells the court that, look, this is a national group. They are taking this seriously. Maybe I need to take a second look at it because I've never seen an amicus. We don't see a amicus in support of cert all that often, or the Sixth Circuit doesn't see amicus in habeas cases very often. Certainly not from the Juvenile Law Center in Philadelphia, who was very helpful at that time. And that what that does is it helps you show the judge that the advocate standing in front of them isn't just some crazy public defender or someone who's just made something up, but there is serious law behind this that other lawyers are agreeing with and saying that it's important, and it gives you credibility when you really need it. That's why I'm also very glad I have partners on my cert petition for Chazz Bunch, so it's not just me from a public defender's office who they've never seen before. It's someone they've seen before, and they'll be much more likely to take it seriously. And it was doing the oral argument in the Sixth Circuit, and this was a humbling experience just to see how unseriously those judges took this claim, how much they thought that this was just not even close, that it was an odd experience. And if you just read the opinions, you think it's very strong, but then you show up and talk to an actual judge, and they will often look at you like you're crazy. And one way I pitched it to them that didn't work is I tried to ask them if they would want me to interpret an order that they gave me with as much good faith as the state was asking them to treat the language from Graham. And that didn't work, but I think that's the kind of thing we need to convince these courts of, is that this is really what it says and you need to follow it.
Let me follow up on that a little bit. Do you think, whether it's NACDL, whether it's individual academics like me or others who are interested in doing amicus work, in addition to doing the filings, should we make a habit, should it be part of our desire to request either extra oral argument time or request of the local counsel that they share some of their argument time, because I very much agree with your instinct that there's a signaling value in just having a national group or others say this is an important case. What I'm not sure about, especially because my sense is when it's an amicus on one side, courts will be resistant, appellate courts will be resistant to giving extra oral argument time. They'll say if you want time, take it out of the time provided to that side's attorney. Again, my sense is every case will be different. You have to make that strategic judgment different ways. But would it be better or worse for the NACDL to think seriously about making part of its at least default standard operating procedure not just filing, but at least thinking about seriously requesting argument time for any case that's naturally going to be given argument time under local practice?
Generally, I think the answer should be no for a couple reasons, but there are exceptions. First of all, my experience with sharing oral argument is that it just doesn't work, unless there's something very distinctive to say. And our office had a case involving sex offenders in the Ohio Supreme Court, and a victims group actually filed an amicus on the side of the criminal defendant. We wanted them to have oral argument time just because it didn't matter what they said. Just the fact that victims were up there saying that they supported us was what mattered. I also think if national groups get too pushy with oral argument time, they may push local counsel away. In one fear that those of us who've been working in the trenches on this case have is that when we work on the case in the trenches for years, then finally it gets to a place where someone's paying attention to it, and then someone wants to snatch the case away just at that point. And that's from the personal and professional perspective. But more importantly, and this is something I've done as amicus chair of the OACDL in dealing with someone recently who got a case into the Ohio Supreme Court on what we thought was an important issue, but she had never argued in the Ohio Supreme Court before and had only argued in the lower courts a couple times. Instead of just taking her oral argument time, what we did is we brought her in. We offered to give her a couple moot courts. I brought her to the Ohio Supreme Court one day of argument so she could see the dynamics. After she did that, then we came back and did a moot court. We offered help during the briefing stages, and we filed an amicus brief in addition to that. And that has, first of all, that's the benefit of not pushing away a lawyer, and secondly, it has the benefit of helping to develop the next generation of lawyers. And there's a very good established U.S. Supreme Court bar who's very professional. I think it's the best. One of the best things we can do for the profession is increase the size of the criminal defense U.S. Supreme Court bar and bring more people into that.
I think that's a terrific insight, and that's itself another part of the story. I'm cautiously, I won't say optimistic, hopeful that Bunch will get granted, but that if it does, you'll discover there will be lots of people very eager to help you, hopefully you preserving the argument, to get that kind of experience. And not speaking for Norman or NACDL here, but my sense is if and when there are cases in state Supreme Courts, NACDL has the means and the resources and the connections to think about, for these kinds of cases, doing the same kind of mentoring that you suggested for the local council, that whether it's setting up moot courts, it's certainly something that with technology we can do on the phone. I've done some phone moots that are still very valuable, and I think that's a perfect way to think about the role that this project can play vis-a-vis oral argument, not necessarily thinking about NACDL playing a direct role beyond the briefing, but particularly once there's that briefing investment, that the folks involved in the briefing and maybe some other folks who have done some work in this area could be part of a team of folks that are at least available, if not actively encouraging the local council to work on oral argument, to think about how to prepare themselves most effectively after the briefing stages for what comes next. And so with that particularly in mind, I'd like to turn to the Miller follow-up case that I'm actually personally getting a little bit more involved in, and that is another frontier in Ohio of a case you've worked on that takes the Graham and Miller cases and explores what their next stages might be.
Well, the Eric Long case started in Cincinnati a couple years ago. Eric, when he was 17, was in a car that was involved with a freeway shooting involving assault rifles, where another car was where people died in that car. He was also in a van that shot up a house. Fortunately, no one died in that house. There's question whether he was one of the people holding the gun or not. Nevertheless, he was convicted of aggravated murder and given a formal sentence of life without parole. His trial attorney at least had the foresight to raise an Eighth Amendment claim. It was then raised again on appeal, and the State Court of Appeals opinion came out 8 days after Miller, and they wrote an opinion that said, first of all, well, Miller doesn't apply because this is a discretionary LWOP, and it was. The judge did not have to impose LWOP, did not have to impose life without parole on him. But then also, well, this judge did consider youth as a mitigating factor. Well, the court then cited a paragraph, and you read the paragraph, and there's no words in it that indicate that the court considered youth as a mitigating factor. And if the court just followed Ohio's sentencing statutes, none of the youth is not an official mitigating factor in the factors that are to be weighed. I guess you could put it in the any other category, but there's no reason a judge would consider it on her own. Then I got the case as a discretionary appeal to the Ohio Supreme Court, the equivalent of a cert petition in Ohio. We call it a memorandum in support of jurisdiction. I filed that. Eventually, I lost the first round 5-2, but I kept on filing supplemental authority. And fortunately, by the time I lost that 5-2, there had been a number of GVRs from the U.S. Supreme Court in similar cases out of California. And I think that I submitted up four supplemental authorities in that case, and then argued that in the motion for reconsideration, and it switched from 5-2 against to 4-3 in favor. And so they've accepted the case. We do have one challenge now, is that in January we got 3 new Ohio Supreme Court justices, and 3 of the 4 justices who voted to take my case are no longer on the court, which means we have a little bit more of a challenge than we did before. But I think it's a very good case because it sets up the issue of what is actually needed. What do you have to do before sentencing a child to life without parole in prison? How much do you have to consider? And one thing the NACDL is going to be able to help with in here is giving a more national perspective, explain what's going on all over the country. I've pretty much settled on the idea that given the strong language of Miller, I need to ask for a full death penalty-like mitigation hearing, minus only a few things. Which in Ohio, you get 2 lawyers that.
So play out that idea of what that means. In other words, what strong language in Miller do you think supports the idea? And we've seen this in some lower courts, and I'm going to talk about that in a minute. But that we're not just saying you have to have discretion in the hands of the sentencing authority at the time of sentencing a juvenile to life without the possibility of parole, but it sounds like your argument is you need to have a comparable sentencing proceeding where every potentially relevant mitigating factor can be brought to bear before a court is allowed to use its discretion to choose a life without possibility of parole sentence for a juvenile murderer.
Right, because the U.S. Supreme Court based Miller clearly on cases like Penry, which required the presentation of mitigation evidence. We also have good case law in Ohio that says that just because you asked for it doesn't mean they actually considered it. And that if it's and they also good case law that says if it's a mitigating factor, courts must consider it. And there's a case from the Ohio Supreme Court that says that. So you do have to look at local law and compare it to U.S. Supreme Court case law. But Miller was based on death penalty cases. It says this is the juvenile death penalty, and therefore I think we need to start treating it that way. And I can't think of something less than that we could actually ask for that would be plausible, because I don't see any room between full mitigation hearing and just the lawyer showing up and saying, please, my client was a child, please take that in mind.
Right.
There really is no middle ground between those. There's no plausible middle ground that anyone can take.
Well, ever the academic, I'm sure I could devise, were I asked to do so, some at least plausible middle ground, but I think that's certainly right, and is one of the many reasons why I look at Miller as this extraordinary opportunity, both for juvenile sentencing purposes and even more broadly for possible movement of the doctrine away from mandatory sentencing schemes in a number of contexts. And let me unpack that a little bit, both to talk a little bit about what I'm already seeing nationwide in response to Miller on these kinds of issues, and also on where, again, I want to leverage this, at least I'm hopeful, the NACDL's project can help people leverage this into broader attacks on mandatory sentencing schemes. As you mentioned, Steve, and it's exactly right, the Supreme Court referenced its capital litigation, what it described as its precedents requiring individualized sentencing, to justify the ruling in Miller that though it's possible to sentence constitutionally a juvenile murderer to life without the possibility of parole, that should not happen in a mandatory scheme. And then they suggest in a variety of ways that youth is a constitutionally essential mitigating factor that at the very least has to be considered. The open and interesting question is, well, what does that mean? What is it about youth? Is it just, and this is your point, Steve, is it just, well, factually my client is not yet hit 18, so therefore give him a break, or is there much more there? And I'm very eager, not only as my own kids emerge from different stages of youth, to notice how youth means very different things for different individuals, but also that I don't think any aspect of the Supreme Court's individualized sentencing jurisprudence is about any one particular mitigating factor. It is about this idea, and again, it's the capital litigators who deserve a lot of credit, not only for pushing this constitutional jurisprudence, but also pushing state law along with it, that every factor that can be a basis for helping a sentencer understand the inappropriateness and ultimately the illegitimacy of a certain sentencing outcome ought to be part of the process of deciding what this particular defendant's fate is. And here's where I'll get poetic to some degree on not only Supreme Court jurisprudence, but also kind of our commitment to justice in our country. We've never held to the principle that just because you commit a particular kind of crime, you always should get a particular kind of sentence. And in fact, this is where I'll even throw in historical clemency doctrines that, among other things, were enshrined by the framers in our Constitution. Even if we understood there might be value in having a kind of mandatory commit this crime, get this punishment kind of scheme, the framers of our Constitution thought it so important to ensure, and this was of course a world much less encumbered by courts than we have now, that the President of the United States must have the power to temper that vision of crime and punishment with mercy. And needless to say, the President's got a lot to do. Needless to say, the framers appreciated the challenge and, in many respects, in my view, the concerns with giving the head of the executive branch a king-like power. Notwithstanding those sets of constitutional concerns, they still invested in the chief executive this absolute, at least according to the Supreme Court, regulable power to do mercy, to essentially ensure this kind of individualized treatment by our system in the administration of criminal punishments. And so, to me, and now I'm very much sounding like an ivory tower academic, these individualized sentencing principles are not a story of, well, death is different and we've invented this special set of rules for death sentencing. In fact, it, to me, is a story that we see expressed in a variety of kinds of ways, that sentencing is different, and our historical tradition in America, and to a large extent internationally as well, in most of the countries at least that we take pride in, that before we decide whether and how a person is to feel the sanction, the condemnation and harm of the incredible, awesome power that is the state, any relevant aspect of who they are and what they did not only needs to, but has to be part of the sentencing decision-making. So here, the outlier is not, in my view, individualized sentencing. The outlier is any form of mandatory sentencing that aspires to say, just because you've committed X crime, that means we know for all intents and purposes in all settings that you are going to and should suffer Y punishment. And of course, and I don't need to lecture to this audience, we know that prosecutors not only embrace that principle, they depend on it. Their own ability to individualize their prosecutorial choices is itself one of the reasons that mandatory sentencing schemes are so, in my view, unjust, because it's not a story that we don't have individualized sentencing when we have a mandatory sentencing scheme. It's that prosecutors get to decide who gets individualized justice and who doesn't. And in fact, that is, of course, and again, sorry for my soapbox, but I can't resist, the real underbelly of Miller and Jackson, the two cases that led the Supreme Court to strike down mandatory LWOP for juvenile murderers. Prosecutors had complete discretion to decide, both formally and informally, whether these kids would be bound over in the way they were, facing the charges they faced, which would invoke this mandatory life without parole possibility. That's no longer constitutional for kids who commit murder. But what that means, not just for kids who commit murder, but for all other kinds of mandatory sentencing schemes, is what I am, personally, am extra eager to try to push the envelope vis-a-vis the Miller doctrines. Importantly, and this is an important point that gets to the heart of Steve's case, and I want to emphasize it, even, and this is maybe why I like pushing Miller in every direction, even if we strike down mandatory sentencing schemes, we have the problem, and it's a significant one, of presumptive sentencing schemes, both presumptive in law. So this seems to be what's happening in California. My understanding of California law, and here I'm certainly not a specialist, but they've had some of the largest number, large state, of post-Miller litigation over the issue of LWOP sentences that aren't technically mandatory, but as I understand California's law, there's a strong presumption to impose life without the possibility of parole for any first-degree murderer, and absent an incredible showing, every judge is going to do that as a matter of course for any 16 or 17-year-old murderer who's been brought over to the adult court. The California Intermediate Appellate Courts so far have been pretty darn good at saying, presumptive schmumptive, this is essentially mandatory. And it certainly doesn't enable a defense counsel to develop all of the mitigating factors surrounding youth that we read Miller to require to come into consideration. And so California, at least in its intermediate courts, have pushed Miller to extend to presumptive sentencing schemes for juveniles getting life without the possibility of parole for murder. In Ohio here, we're dealing with a discretionary scheme, and I'll leave it to you, Steve, to tell me, are there unique facets of Ohio's discretionary scheme that are part of the argument, or that you think might come up in the Ohio Supreme Court? Is it simply the fact that the judge didn't engage with the issue that you think is presenting the best hope for getting the Ohio Supreme Court's attention? And in the course of advocating for a full mitigation hearing, are you concerned, or are you preparing for, at oral argument, the pushback that says, well, are you saying essentially we need to have separate penalty phases for all of these cases because that's what we have in the capital arena?
Well, I can't do the penalty phase, the separate penalty phase, because there's clear Ohio Supreme Court case law that says you do not get a jury for sentencing. They said that after Blakely came out, that was one of their reactions to Blake. They said, nope, you can't get around it that way. So we do have a separate hearing. It's just before the judge. One problem we have is in Ohio is judges are trial judges in Ohio traditionally get gigantic amounts of discretion. Appellate courts, even when the law says they're supposed to review sentences, appellate courts are loath to do so. Even when we had a statute that said expressly they must make certain findings before they give someone a maximum or consecutive sentences. Most lower courts were saying, and they have to make those findings, quote, at the sentencing hearing. Most of the lower court decisions said, well, they have to make them at the sentencing hearing, but it doesn't mean they actually have to say them. We assume if they give the consecutive sentence, we assume that they thought that. And I'm not joking. And when we got that to the Ohio Supreme Court, we only won that issue 4-3. So that's one problem. We have is incredible trial court discretion. But,
and let me follow up on that. Do you think you'd have a chance, whether in front of the Supreme Court here or subsequently as these cases unfold in Ohio or in other discretionary jurisdictions, in arguing for the resources to develop the kind of mitigating file on behalf of juvenile murderers that are becoming a matter of course on behalf of death penalty defendants?
I think we're going to have to deal with that in the Ohio Supreme Court, because if we lose it there, I think we either win or lose that in the Supreme Court. That we'll get guidance from that. I also think that we can take Miller beyond sentences labeled life without parole, and we can even take it beyond children, because It doesn't require sentences in other certain sentences in other cases. It doesn't require judges to consider youth as a mitigating factor quite as clearly, but there's still lots of good science in there, again, that has 5 votes, that talks about how 14, 15, 16, 17, and if you look at the studies that they cite, actually 18, 19, 20, 21-year-olds just aren't as responsible for what they do as older people, as either adults or older adults, and that's science that you can use anytime you have a 19-year-old defendant, regardless of whether it doesn't matter if they're charged with aggravated murder or weapons under disability. You can say, hey, look, this is a child. Children are stupid. They do stupid things. When they grow up, they stop doing stupid things. That's why you don't see many 40-year-old murder cases committed by 40-year-olds coming before you. So I think we need to make sure we don't limit this to just.
Well, and I'll take it even further, and so just to play out the theme of some of the things that I've been thinking about and eager to figure out whether there are ways to develop jurisprudence in lower courts, in state courts, maybe using state proportionality doctrines to attack mandatory sentencing. The broadest reading of Miller that I want to give, and I understandably get pushback in a variety of ways, but this is what an academic makes his living on, is thinking extra levels of abstraction. I want to read Miller not just for youth is different, and because of the difference of youth, whether it's brain development, whether it's impulsiveness, whatever the factors are, whether it's that LWOP is necessarily the longest possible sentence because you're youth, whatever the case may be, whatever leads us to say youth is different, and youth means you can't have a mandatory LWOP sentence. I want to read that for the idea that there are some facts or factors that the Constitution makes mitigating. Period, stop. I think that's largely where we're getting to with youth. I think the right reading of Roper and Miller, along with Graham, is youth is a mitigating sentencing factor, and Eighth Amendment constitutional doctrine demands a set of special principles when that mitigating factor is in place. One special principle is you can't have the death sentence. Another special principle is you can't have an LWOP sentence for non-homicide. Another special principle is you can't have a mandatory LWOP sentence if it is a homicide. But let's think about, or at least this is what I'm going to particularly encourage those using the NACDL resources and perhaps working with me, what other factors we might think are constitutionally essential as mitigating factors. And what do you have in mind, Berman? Well, here's one that I'm already working on. Compliance with state law when you're facing an extreme federal sentence. Well, what kind of cases are those? Well, those of you who maybe follow a completely different area know about what's going on in California, going on in now Washington and Colorado, even with recreational marijuana use, certainly has been going on in a number of states with medical marijuana use. The federal government, for political and other reasons, has been quite resistant at binding itself to any of the state liberalization of marijuana use. And in fact, when they come in to prosecute those who they think are, in their view, abusing state law, in order to run large marijuana grow factories or do other things that, though perhaps at least attempt to comply with state law, the feds come in, and not surprisingly, because marijuana remains a Schedule I drug, it's not just that it's a crime under federal law, it's still subject to an extraordinarily number of large and severe mandatory punishment schemes. And one of the many ways this is played out is disproportionately, of course, a medical marijuana dispensary that's trying to do its job well is growing lots of plants. Well, the number of plants triggers a mandatory minimum under federal law. If you have any kind of prior conviction, that triggers heightened mandatory minimums under federal law. Not surprisingly, some of the people who get involved in these industries may have a criminal past. If there are weapon use involved, again, another mandatory minimum comes in. Now, does that mean all of those are constitutionally violative? I doubt any court will reach that conclusion anytime soon. But the idea that compliance with state law, now this would matter setting to setting, proving compliance with state law is a lot different than proving your client's under 18. So it's a much more contestable fact. But I think as a factor, and again, this is the academic in me speaking, if you think about the idea, should you be able to argue at sentencing that though you're being subject to a long federal prison sentence, that should be mitigated because your entire criminal activity was an effort to comply with state law. I think the framers, who of course were very concerned about federal power and very eager to preserve state power, would very much think that's a constitutionally significant mitigating factor. And here again I want to emphasize the nuance and to some degree the challenge in any sentencing advocacy. It's dangerously easy for courts, even for litigants, to say compliance with state law precludes federal prosecution or should allow a dismissal at the outset. And there's a 10th Amendment argument, or there's a Commerce Clause argument, or a range of other arguments that can be, and often are, usefully marshaled to make broadside attacks on facial laws that we're concerned with at the federal level or at the state level. In sentencing advocacy, you might try to make that, but that shouldn't be the only arrow you shoot. The idea that even if it's not a problem under the 10th Amendment, even if it's not a problem that the feds are coming after my guy, the fact that they're coming after my guy and doing so with an extremely long mandatory minimum sentence, and they want to emphasize at sentencing that compliance with state law is not only irrelevant, but should not even be able to be considered by the sentencing authority before these extreme penalties are imposed. Now again, am I likely to get much credence from that other than in law review articles? Not so much, although I'll give a plug to a wonderful recent article by Professor Mannheimer, who has developed the idea that state practices in sentencing ought to be a defining metric for judging federal sentences under the Cruel and Unusual Punishment Clause. He develops a lovely, lovely set of historical arguments, and of course this is important because of the originalist turn in our modern Supreme Court. He has a lovely set of arguments in this article which will end up on the NACDL website. One piece of the website is going to include leading academic commentary that might be useful in developing creative arguments in this arena. And his article, I believe, is titled Cruel and Unusual Federal Punishments. And the theme of his article is the proper benchmark for doing the kind of comparison analysis for Eighth Amendment purposes for federal sentences is the range of state sentences. And again, I encourage everybody to imagine, right? So this is me as the academic setting out a ridiculous but amazingly not so far-fetched anymore hypothetical. Imagine a case in which every state in the country, and let's throw in D.C. and Puerto Rico and others, have all said either this criminal behavior isn't criminal, you're allowed to possess or use small quantities of marijuana medically or for other reasons, or if it is criminal, it's subject only to a fine, right? So it's not completely decriminalized, but it has been kind of become a low-level offense of the lowest dimension, maybe even say comparable, to overtime parking or speeding. But here in federal court, that exact behavior, notwithstanding it would get you no more than a fine in any other state, is now subject to a mandatory decade in prison. That not only strikes me as unusual, it's also kind of cruel. And put it differently, this is the point about Miller, you wouldn't necessarily have to argue that you can't give 10 years. The argument is, under Miller, compliance with state law is a constitutionally significant mitigating factor, and so it's unconstitutional for the sentencing authority not to be able to give effect to compliance with state law in the same way it seeks to give effect to youth or what might be other constitutionally required mitigating factors. And let me just throw in a couple more because it's part and parcel of some of the things that I've been thinking about to extend Miller and Graham. The most obvious one, and Steve may have clients that fit this bill, and we can talk about that hopefully on the practical level, defendants who suffer from mental retardation. Clearly, Roper comes to be and relies on the mitigating factors of youth, building on the Supreme Court's case in 2002, Atkins, which said those who are diagnosed mentally retarded are categorically ineligible for the death penalty. I think it's not only fair, I think it's almost a given that they would apply Graham in the right setting to a mentally retarded defendant. Now, it's relatively rare that a mentally retarded defendant gets a life without the possibility of parole sentence for a homicide crime, but there are probably some out there. Some of the folks listening to this may be representing those individuals. Obviously, there's been a big debate over that category of mental retardation. Nevertheless, the Supreme Court has said without any uncertainty in Atkins that mental retardation is a mitigating sentencing factor for death penalty purposes. Why that would not also apply in all the settings that Graham and Miller apply to. Another one that I'm particularly gung-ho about these days concerns status as a veteran. The Supreme Court has some very good dicta in a case called Porter that dealt with death penalty sentencing and the importance of the relevance of past military service as a mitigating factor in a discretionary capital sentencing proceeding. And among the things that are valuable potentially for clients who are veterans is a combination of their prior good works, the relevance of just simply their status of having served their country, hopefully in a distinguished way and having been honorably discharged, but also the reality, often underdiagnosed, often underserviced even when diagnosed, of traumatic brain injury, of post-traumatic stress disorder, a variety of service-related mental illness. And one of the things that makes veterans a particularly appealing group of offenders on whom to leverage these kinds of arguments is, unlike other defendants who may suffer from mental illness as a result of perhaps bad childhood or a range of other difficulties in their personal background, the argument can be made, often the argument is perfectly accurate, that their brain injury or their post-traumatic stress disorder, their mental illness, was a direct result of having served our nation. So the idea that not only having served our nation should be a mitigating factor that can be considered at sentencing, but that the mental illness that resulted from serving our nation, the idea that that categorically can't be considered in a sentencing system strikes me as not only cruel and unusual, but such a disaffinity for the rhetoric we hear all the time about honoring our veterans and giving them the treatment that they deserve when they return home. And I'm sure Steve can give me chapter and verse about a variety of clients he's faced who have military service and the way in which the lack of stateside servicing of folks when they come home itself serves as a criminogenic element. And so thinking dynamically about other offender populations, thinking dynamically about other kinds of aspects of a defendant's background, character, or behavior that we can make a forceful argument is a constitutionally essential mitigating sentencing factor is what I think Miller gives us a unique chance to at least explore conceptually. Whether we get cases that reflect that remains to be seen.
And I'm saying and one thing I think is important is I don't think we have to win these issues to have them benefit our clients. And he was talking about the medical marijuana case, or the one thing you should never do in a medical marijuana case, or where someone is actually legitimately following state law. You never want to start your brief with, my client was indicted on whatever date. If you can tell the story, if you start with him starting his business and walking through how he built it up and how all the efforts he followed all of the efforts he did to try to follow the law. Maybe another example with the military service, I had one guy, it's the sex offender case where my guy did have some military service. I made sure I included that in my stay motion, and I did get a stay pending appeal that kept him out of prison. But what if you tell a compelling story, and you can use these legal arguments to bolster your compelling story, even if you lose them, that suppression issue might look a lot better to the court than it did before, and you might win the suppression issue you didn't win before, or you might win another resentencing involving the sentencing issue. And I've had a number of cases where I've won, where the court has bent over backwards to give me something, even though I lost on the main issue I raised, because they got mad at the prosecutor for bringing such a penny ante case or prosecuting someone who was trying to do the right thing. And I can't emphasize enough that we lawyers tend to be really bad storytellers, and we need to think about our factual section as not just the last thing we do. It should be one of the first things we do. And if I can plug one thing here, I said the best legal writing book I've ever read was not written by a lawyer, it was written by Stephen King. It's called On Writing. And if you want to learn how to tell a story, read a book written by someone who gets people to pay him $30 for the privilege of reading 600 pages. And he has, and there are other books like that too, but And one of the best pieces of advice I got from there is when I start writing my factual statement, I will often put away every piece of paper I've looked at, every document I looked at, and just write a story. Now, obviously I have to come back and edit it. I take things out. I get things wrong. But look at the story, and you'll be amazed at the things you will win when you've told a good story that you thought you never had a chance of winning.
And I would echo that, and again, sort of try to bring in the role that NACDL can play, the role that amicus work can play, because every story in the criminal justice system, on the defense perspective, has some ugly elements necessarily to it, right? So part of that is, no matter who the client is, no matter what the case is, there are ways to tell the story to give it the best persuasive, equitable punch. But what an amicus group can do, both in helping the drafting of the brief, but also in thinking about how issues will be developed. It may well be the case that developing these creative arguments in a brief that has other stories that are more important to tell in the brief proper is exactly what NACDL can do when they come in. Allow the advocate to only have a few pages. You still want to preserve it. It's still critical to preserve it. Particularly critical, maybe even to flag if there's been coordination effective ahead of time, that this amicus brief will be covering these issues. But it allows the storytelling not just to be about constructing the fact statement. It's about making sure the overall brief and the themes of the brief connect to the most potent stories, what you want to make sure the judges are paying attention to, and then being able, in some sense, to delegate to others who don't need to tell the story the same kind of way. One of the things that I love most fundamentally about doing amicus work is I don't have to worry about the facts quite so much. And that's, in fact, one of the things that can vary state by state, setting by setting, how much an amicus can get away with, not engaging with the specific facts of the case the court's considering, and how much it's appropriate to talk about broader issues and to bring in other jurisprudential principles. But especially, and this is a point that I want to emphasize at this stage in particular, there may be limits, both actual limits, but more likely strategic limits, in state courts especially, in arguing other states' laws. I mean, I certainly know my own impression strategically is if I see somebody arguing non-controlling authority or persuasive authority from somewhere else, I'm inclined to say, must be they have pretty bad controlling authority.
Well, actually, I think maybe that's in the lower state courts, but I know when I'm in the Ohio Supreme Court, they really care what other state Supreme Courts have done. They really care what's going on elsewhere, and if you could show them that if they rule for the state, they're going to be the outlier, you are much better positioned, because it's hard. Judges don't like to stick their necks out.
Right.
And if you could show them you're sticking your neck out, if you go for them, you're in much better position.
And that's very much, the point I want to highlight is there will be times at which, whether it's just the resources we assemble on the NACDL website or work we're able to do throughout this project, it may be the case that in a lower intermediate court, that's the time when an amicus or somebody else can come in and develop a story about foreign law, for lack of a better way to describe it, whereas then not only is that story prime, but then you're in a great position to not have to reinvent the wheel as you move from that intermediate appellate court to maybe even the equivalent of a cert petition or something along those lines. And one of the things that Stephen's been wonderful at helping me and Norman think our way through, but that is one of the sort of pregnant leftovers from this project, is this idea that we want input from the practicing defense bar about how this resource can be leveraged effectively, both in light of your local conditions and in light of just the broader movement of this jurisprudence. One of the things that is at the sort of foundation of what got Norman and I think, so excited about investments here is the buzz after Graham was it was going to take many years before we got to Miller, that we were going to have litigation over all the attributes of Graham for a decade or more before the court would take up a juvenile murder case. And as we were having that discussion, or 2 weeks after that, they granted cert on this. And that's itself another piece of where, if you don't ask, you won't get, but it's also another part of where I'm very confident this is going to be a dynamic and evolving area of law. Whether the Bunch case is the next cert grant, whether we win big on Long and then the state files for Supreme Court review and we're there for that. Who knows how we're going to get there? And I do want to wrap us up and want to give you, Stephen, a chance for last thoughts. But I think it's important to emphasize that nothing is set in stone about this project, and the more feedback we get Me personally, you can track me down hopefully pretty easily through the website and other means, and NACDL, about how developing this resource will help engender, as Norman said at the beginning of the program, the kind of strategic litigation that I personally think is essential to ensure not only this jurisprudence moves forward effectively, but achieves all the things that I know it has the potential to achieve, but that it only will achieve with the very best advocates pressing the very best ways for the very longest period of time. And as everybody knows, perhaps all too well, even short-term victories can end up being snatched away, whether we look at the success of Furman, and then that leads to Gregg, whether we look at other seeming successes. Maybe Blakely and Booker would be part of this in other sentencing settings. There's always going to be fits and starts. There's always going to be setbacks that go with any victories. But if we work together, not just strategically, but with the spirit of this being the kind of work that's exactly what defense lawyers are uniquely able and uniquely responsible to try to do, I feel very confident that we'll have many more successes and things to celebrate than setbacks to lament.
Well, and one thing we haven't discussed, I think we need to find a way to address it. It's one of the hardest problems. Is I see far too many sentencing transcripts. Again, I only do appeals. I rarely show up in trial courts for sentencing hearings, and I've never stood in front of a jury. But I see far too many appellate records where even when the sentencing hearing is contested, the defense attorney does little more than read the pre-sentence investigation report and beg for mercy. That we've got to find a way to make that stop. We've got to find a way to, at least at a minimum, have that defense attorney walk through the sentencing factors. But sometimes to think more creatively, would a psychological expert really be helpful, and can I justify it? I had one brief story where I had a client, I got her on her second or third appeal. She had been sentenced already 2 or 3 times, each time to the maximum 10 years for manslaughter. I think it was only 2 times, but both times the trial lawyer just showed up and did what I said. The third time when it went back down, he ended up getting one of the best appointed counsel in town. She got an expert. We were able to work with the Department of Rehabilitation and Correction to find an inpatient treatment place for her, and she went from maximum 10 years in prison for manslaughter to community control and inpatient treatment, simply because the trial lawyer actually worked the case and did her job. And that's what we need to, more trial lawyers need to do. That needs to be the rule, not the exception. And to the extent that we can create an atmosphere where, if maybe through peer pressure if nothing else, where a trial lawyer who does that is going to be looked down upon by his or her peers, whatever it is, we need to find a way to make that change. Because if trial lawyers don't do things, if trial lawyers can do things right, then we appellate lawyers never have to mess with the case, and I'm much happier when that happens.
And again, that's something that I'm eager personally, that I know NACDL is eager to figure out ways to make it easier. It's a resource issue, I know it's a time issue, sometimes it's often, and I've been surprised with this, but it's discouraging. It's a matter of local practice, that even if a defense attorney wants to be very aggressive at sentencing, that engenders some pushback from the trial judge. They have busy dockets. You ask for an evidentiary sentencing hearing and you want to put forward evidence, and they're like, well, I don't have time on my docket. And so, not only is there understanding of a range of forces that may conspire to make it hard to have the resources, both personally and professionally, to make and preserve these arguments. The reality is that's the foundation for enabling this jurisprudence to move forward, and particularly, as probably everybody listening to this knows, far too many courts, particularly when there's an effective substantive argument, are eager to find a waiver or some means to dodge it. And the key is not to beat them up for that tendency as much as to not give them excuses or opportunities to dodge those hard issues, even if they end up going to come out the wrong way, that they have to confront them and engage with the substantive arguments we're putting forward is an accomplishment both in giving our clients, giving defendants a belief and hope and understanding that the system is listening to them, that their voice is heard in one capacity or another, but even more to ensure that judges, prosecutors, everybody who's witness to what's going on regarding our clients know the full story and understand fully the moral and social realities of what extreme sentence necessarily involves and why we work so hard to avoid them and to do whatever we can to move the constitutional jurisprudence to be part of that pushback. Thank you.
Thank you.